Hey, good afternoon. Welcome to our latest podcast. We're down in Virginia at ALPA headquarters. We came down here with the executive to discuss, options, what's available to us, support, increased support.
Yeah,
Tell us a little
three
bit
days
about.
of meetings with ALPA legal, ALPA SMEs, subject matter experts on what we have upcoming with our
Yeah,
negotiations, with legal support, comm support, and how all the pieces fit together for the WestJet Pilots. And it was a really good week. Down here. It was your first time down here.
it was. It was. It was really good.
What do you think?
Quite enjoyed it. Yeah. I think we got exactly what we needed. Super impressed. Andrew Shostak actually said, "Message received clearly." So
So
we were
lots of
on
changes
track.
incoming
Yeah.
for support for the WestJet MEC in Calgary and across all our bases for all the pilots at WestJet. And really looking forward to the upcoming year as we do this. We have a Negotes survey that we're launching. So please, looking for all pilots to fill out that survey and make sure that your priorities are heard for the MEC to direct our negotiations for things that you need in this upcoming round of negotiations.
And I think you've got an interview.
I have an interview coming. It's with Evin Isaacson, who is an ALPA lawyer specializing in scope language within collective agreements.
Excellent. Let's get to it.
And so we're at the ALPA building now. Introduce yourself, what you do at ALPA, and just please tell those watching this video why you're so passionate about scope.
Sure. My name is Evin Isaacson. I'm a senior attorney in the legal department. I have been with ALPA since 2018. I've been working on pilot scope issues since 2013. And I'm passionate about scope because I do think that it is the foundation of all of the collective bargaining that we do. And this is where we have seen so many explosions of management creativity. And so there's a little bit of a cat and mouse game, but there's also elements of understanding the economics of the entire airline industry and trying to make sure that we're protected as that industry evolves. And so it is complex and it is hard and it is so important and it feels foundational. And I've had the privilege of working with a number of different pilot groups and being part of numerous scope arbitrations and scope negotiations over the years. And I'm looking forward to continuing to do so with the WestJet.
So I'll just ask you a bunch of questions that we've kind of gone through a few of them here and go from there. Evin.
Hi.
You're a lawyer who works specifically on pilot scope contracts. Before we go anywhere else, in the simplest terms possible, what is scope in a pilot contract and why should WestJet pilots care?
Scope is Section 1 for a reason. It's what protects pilots' job security and ensures that the terms and conditions of the collective bargaining agreement that you negotiate for actually apply to the flying done by the airline.
And like, if you could walk us through like a real life example, like what actually happens to pilots at an airline when their scope protections are weak or missing? Like, what does that look like in practice?
We have learned over the years that managements are creative in trying to figure out ways to evade scope protections. So we try to draw the broadest umbrella possible for what flying is covered by the agreement. And we try to do it in the simplest terms so that way you don't get shell games. We have seen outsourcing to regional carriers. We've seen exceptions that were granted for puddle jumpers turn into huge threats to pilot job security when the jet engine enabled cross-country flying on small jets. We have seen managements create new holding companies that are wholly owned by the same company and set up alter egos that try to do the flying in place of the pilots on the seniority list at the carrier in question. There is no limit to management creativity here. And in the absence of contractual protections, you better believe that they are going to try to find a way to evade the protections that our pilots bargained for.
Sounds somewhat familiar. So WestJet pilots are often told, don't worry, the company would never do that. How do you respond when pilots say they trust management and don't think strong scope language is necessary?
I am so glad to hear that some pilots have a really good relationship with management. That said, I'm a lawyer, and we are in the business of making sure that we trust but verify and have enforceable contract provisions that force management to put their money where their mouth is. Essentially, in the absence of strong scope protections, well-meaning managements can change. Companies get sold, there are mergers, there are new people in charge. And so if management was going to be growing the airline in a way that shared that growth with the pilots who are employed by that airline, it should be no problem for them to put those guarantees in contract language.
So further to that, what is an alter ego airline and why is an alter ego prohibition such a critical part of a pilot contract?
This is that holding company shell game that I mentioned before. Essentially, managements can use different corporate forms and different holding companies and subsidiaries and affiliates to have another technical corporation be performing flying that benefits the airline in question or that flies on behalf of the airline in question. And what you don't want to see is management playing those corporate shell games in order to evade the protections in a collective bargaining agreement.
Makes sense. So WestJet is continuously expanding internationally through Codeshares and interline partners. How do codeshare and international protections in a contract stop that growth from effectively coming at the expense of WestJet Pilots?
There may be good reasons for an airline to have partnerships with international carriers in order to grow an airline, to be able to get traffic to places that they wouldn't be otherwise able to serve. That said, it is critical that that benefit not come at the expense of career and job opportunities for pilots. So the purpose of scope protections that address these kinds of international relationships is to ensure that if an airline is growing because of international traffic, that the pilots employed by that airline see a fair share of that growth. And there are any number of tools that have been worked out over time that can be used to try to put those protections in place. They take a lot of different forms and they vary a lot based on the business model of the airline in question. But it is critical to ensure that those sorts of airline cooperation relationships don't effectively become outsourcing.
Makes sense. Cabotage is a word most pilots have never heard. Can you explain what it is and why a pilot group flying internationally, like WestJet now does, needs explicit cabotage protections in their contract?
So cabotage is about the carriage of passengers within a particular country. And it is one of the reasons why you can't have a foreign carrier that is based in Thailand and employs pilot staff by a Singaporean staffing agency fly from Toronto to Calgary. That pilot flying should be done by pilots of a Canadian carrier. What I would say is if you've got a foreign carrier who's coming in and then able to pick up new passengers on the ground within Canada and fly them to another place within Canada, that and WestJet can have a relationship with that carrier, that has the potential to enable WestJet to make money off other carriers flying within Canada, which is, of course, the very core of what any flag country airline is supposed to be doing themselves.
It does make sense. On a different topic, what is minimum crew complement clause, and why does ALPA consider it essential, not just for safety, but for the future of pilot jobs as automation advances?
So I am not the expert in reduced crew operations, but we have been putting them in pilot scope clauses because it is so core and so fundamental to what you guys do as pilots. You guys have made a judgment call that this belongs in Section 1 and that all flying performed by the airline needs to be done with that minimum crew complement. The other consideration from a job security perspective is those relationships with other airlines and other airlines that are under different regulatory structures that might not have those protections. So what you don't want is for an airline in a country that has a minimum of 2 pilots in the cockpit to then partner with an airline in another country that can get away with 1 pilot, and then they've got far reduced labor costs. And you can just imagine the kind of labor arbitrage that could result when you could outsource to an airline that only needs to pay to have 1 pilot there on the flight deck.
Makes sense. On a different topic, wet leasing. I'm sure a lot of our pilots at WestJet are familiar with the term, which is renting another airline's plane and crew. Can you explain when that's a legitimate tool for an airline versus when it becomes a scope problem, and what good contractual guardrails look like?
Sure. It's a really good question because there are sometimes legitimate reasons to wet lease in. This particularly happens, for example, when an airline can't hire fast enough, can't get planes on property fast enough, or when they have unexpected fluctuations in demand that they need to ramp up quickly but can't do so. It's particularly an issue in the cargo world where you might have a contract come in and it will enable you to secure a client for the long haul, no pun intended. And so it's just a short stopgap measure while the airline can grow to meet that demand. We see it less often in the passenger world because you schedule passenger flights so far out in advance that you should be able to plan for demand. But there are sometimes unexpected situations where there might be unexpected attrition, there might be unexpected aircraft groundings. So there might be legitimate reasons why you would want to do that. That said, it should be a stopgap measure, and it should not be part of a long-term business plan. As for when it becomes a scope problem, my perspective as a lawyer is that it becomes a scope problem the minute it exceeds the contract language in question. So even if there might be a legitimate reason why management would want to wet lease, they need to negotiate for that with our pilots. And so if they want to do it for a reason that's not permitted under the contract or is for a duration that exceeds that permitted by the contract, that's a problem. And we want management to engage with us. We want to be reasonable, but every single piece of this has got to be a negotiated agreement between the parties, and then management needs to honor that commitment.
If you were reviewing WestJet's current scope language as their legal counsel, what would be the first thing that jumped out at you as the most urgent gap to fix, and why?
Well, so I am not going to say anything that would breach attorney-client privilege here, so let me just speak in some general terms. You guys did really hard work in the last contract cycle to deal with swoop and a number of those unique challenges. However, there are always opportunities for improvement, and there are opportunities for addressing what the anticipated next stage of WestJet's development is. So we have seen some trends among carriers with whom WestJet frequently partners, including Delta, including KLM, Air France, in terms of using new tools for cooperation. And we want to make sure that those are adequately addressed in the contract. And I say that without making a judgment call about what we believe we already own, because that's going to be a legal analysis. But when we are going through the contract to identify priorities, those new evolutions in airline cooperation are something that we're going to keep close in mind.
Some good information. What happens when a company violates a scope clause? WestJet's contract currently has no compensatory damages language. Can you explain what that means in practice if there's a violation?
Let me speak sort of in general terms about enforcement. Enforcement has a number of different goals, right? You want to hold the company accountable to the language of the contract. You want to ensure that the pilots and the association have been made whole for those damages. And you want to make sure that it's not just factored in as the cost of doing business, but that it actually has some kind of deterrent effect. All of those things are legitimate goals for negotiation, but they are going to need to be negotiated. And there may be cases where we think that we have negotiated something and an arbitrator doesn't seem to agree with us, which is one of the situations that the WestJet pilots have found themselves in. There are also alternative means for contract enforcement. For example, you can bargain for automatic penalties that kick in without having to go to arbitration. Those can be monetary, but they can also be things like in-kind remedies. And when it comes to scope, it's often a challenge to identify for an arbitrator exactly who has been harmed and show how impactful that harm is across the association, because management is going to argue, oh, it was just one block hour here or there. So sometimes we find that in-kind remedies, like saying, hey, you were over this limit by one aircraft, next month you need to be under by two, those might be preferable in certain circumstances. So when we go into this next contract negotiation section, that's one of the elements of the contract we're going to be looking at, and looking at new strategies that serve the goal of ensuring that the bargains that we negotiated for are honored by the company.
So WestJet's now flying to Europe and Asia with its own widebody fleet. Does the scope language a pilot group negotiated for a domestic carrier automatically cover that international flying, or are there new vulnerabilities that open?
So we like to say that we are concerned both about flying by the company, as in terms of which parts of the corporate holding company or related corporations are flying. And so if it's flying on the company's aircraft, it's very clearly flying by the company. And that can apply both domestically and internationally. There's also flying for the company, where there are arrangements between one employer carrier and other external airlines. Sometimes those look like outsourcing relationships or subcontracting, but sometimes they can look like things like joint ventures or other sorts of forms of cooperation. And so one of the things that we're going to be looking at is whether we are comfortable with how broadly that umbrella has been drawn in the WestJet contract.
So going on to something that's a little bit more concrete, WestJet has roughly 7 wide-body aircraft and over 150 narrow-bodies. Meanwhile, Condor Airlines, a German leisure carrier, flies directly into Calgary, our home base. WestJet sells seats on that flight. WestJet pilots don't fly to Germany at all. How is that possible? And what does strong scope language do to prevent that kind of arrangement from expanding?
This isn't exactly the sort of issue that we want to be looking at. If a airline is growing, we want to ensure that its pilots are getting a fair share of that growth. And so what we want to do is, first of all, make sure that those sorts of relationships are covered by our scope clause, and then place reasonable limits on them that both prevent harm from the pilots from those relationships and give pilots a fair share of that growth. So there are different mechanisms that we can bargain to figure out how best to address your pilot's concerns with respect to those sorts of relationships. But the key and the underlying philosophy of scope is that if the airline is benefiting and if the airline is growing, they should be doing that using our pilots, and our pilots should be doing a fair share of that flying.
So a WestJet pilot, sitting on reserve in Calgary, looking out the window and seeing a Condor A330 operate the very flying they should be bidding on, like, what specific language would stop something like that?
It really depends on the circumstances. And I know that's a very lawyerly answer, but there are any number of different ways you can achieve that result. And so I don't think we need to lock ourselves into a particular approach. The key is the underlying philosophy of how do we make sure that if WestJet is growing, that our pilots are having those opportunities.
So with less than 5% of our fleet even being wide bodies, a WestJet pilot's career earnings jump significantly when they upgrade to a wide body captaincy. If a company can keep satisfying international demand through interline and codeshare partners instead of buying more wide bodies, what incentive do they have to grow that fleet, and how does that scope language change that math?
So looking at those potential situations of labor arbitrage, where can they make money off other pilots flying, is exactly what the exercise of scope analysis is intended to look at. So what we are going to do is take every one of those scenarios and say, look, where is WestJet growing here? And where does WestJet seemingly want to grow? And how can we ensure that our pilots see a fair share of that growth? That can happen in any number of different scenarios. And ultimately, it's going to be your guys' priorities and the negotiating committee's deftness that figure out where they want to put the bulk of their bargaining capital. But that is certainly something that we should be thinking about actively and figuring out how to ensure that the pilot's interests are served in connection with those kinds of relationships.
So the last time WestJet ordered 787s, they received only about a third of them. And then we've had 7 for a number of years now. They've announced that they're ordering more 787s. So what type of scope language would WestJet pilots need so they actually receive the planes, not potentially just selling the slots to another carrier?
We are always going to be in a situation where we don't run the airline. We don't decide if it's going to grow, and we can't make them receive particular orders. What we can do is say, if you're going to grow in a particular direction, grow with our pilots. So they get to decide how they want to move their business model forward, but we get to say, yeah, and we're coming too. So If they don't want to get those wide body deliveries, great. Then we want to make sure that you're not bringing in wide body revenue generated by some other pilots who aren't on the WestJet seniority list. And that's sort of where the link comes in. Management decides where it's going to take the airline, and we need to bargain protections that ensure that the pilots on our seniority list come with in connection with those efforts.
And that makes sense because right now, WestJet management has paused all hiring and pilot upgrades. At the same time, they are publicly announcing new interline partnerships regularly. From that same pilot sitting at home on reserve, not getting upgraded, watching WestJet and hand more flying to foreign partners, what does that tell us about where scope fits into these negotiations and what contractual tool would have prevented this situation?
It's hard to second guess the priorities from the past because there was a crocodile closer to the canoe at that point, right? But we can look at where we see WestJet going forward and figure out where there are potential vulnerabilities that we want to address. So essentially, there is an opportunity to address those particular sorts of relationships in a more fulsome way. Now, some relationships and some versions of those relationships pose less of a threat to our pilot groups than others. And so for every single carrier, we're going to be doing a particular specific risk analysis, looking at the full panoply of types of relationships that we've seen across the airline industry, as well as looking into the indicators in the industry about where we see evolution that has the potential to increase the risks of certain kinds of partnerships. And so we have seen that evolution in new and surprising ways, and tools that we used to think were less of a threat to pilot jobs and job security are being used in new ways that we consider to be more of a threat.
So a junior WestJet pilot might be thinking, scope is an issue for management and the union executive, not me. What would you say to that pilot about how scope directly affects their personal career over the next 20 years at WestJet?
The pilot profession is so unique in its reliance on seniority. You get your career opportunities by staying with your carrier for the long haul. And so that means that your career is directly impacted by how much flying and growth stays in-house. And so scope becomes essential to that, to ensure that as the airline grows, the pilots on the seniority list who have dedicated their careers and thrown their lot in with this airline see that growth and those career opportunities as well.
100%. ALPA has negotiated scope language for major carriers across North America for decades. Is there a negotiating win, a clause, or a concept that you're most proud of that you think every pilot group should be fighting for?
Every single airline is different, and every single pilot group's needs and priorities are different. But I do think that the general framework that we have developed over decades, where we draw the umbrella of what flying is covered by a collective bargaining agreement as broadly as possible, and then carve out tailored exceptions that meet the particular needs of the particular airline and the priorities of that particular pilot group, is a really powerful approach, and it's one that is the bedrock of all of our scope negotiations. So we always want to be in a position where we are drawing that pool of included flying with as much breadth and robustness as possible.
Final question. If you could give WestJet pilots one message to take away from this conversation, one thing you want them to understand about scope before they vote on their next contract, what would that be?
I would say that it is Section 1 for a reason, and that all of the other elements in the collective bargaining agreement are incredibly important, but they all stand on the foundation of Section 1.
Thank you so much for taking the time today
Yeah.
to take out of your lunch break to chat with me.